Hello, my name is Emily, and I am here today with recognized authority in trust clause litigation, Dan Dalton. So Dan, we have seen large groups of churches leave in Texas. How did those churches accomplish the exodus from the United Methodist Church?
Well, Emily, in short, they accomplished that exodus through strategic case law was developed in the 2000s in the Presbyterian Church exodus, as well as the Episcopal Church. There's a case that the Texas Supreme Court decided back in 2014 called Masterson, and in Masterson, the Supreme Court found that that neither express nor implied trust of the Episcopal Church were recognized as enforceable. So the Episcopal Church has what's called the Dennis Canon. The Dennis Canon is similar to the trust clause in the Book of Discipline, and the court found that it is not an enforceable way to leave a denomination. In other words, there's no hook that's there through their Book of Discipline. After that, in the 2018 or 19, somewhere there, the Texas Supreme Court decided a case called Salazar. And in that case, the court found that the Presbyterian Church USA's trust clause, which is in their book of order, which is similar to the discipline, was unenforceable as well. So with that, there was a number of churches who challenged the United Methodist Church trust clause. One was Southern Methodist University when they changed their articles of incorporation. And the claim was by the denomination that they couldn't do that because it violated the Book of Discipline. Dallas County Court found that they could do that the authority exists under state law as opposed to the discipline for allowing them to change their articles of incorporation and remove the United Methodist Church and the Texas Annual Conference from any type of control or ownership of that organization. Thereafter, there was a case in Blue Ridge, Texas, where Blue Ridge United Methodist sued to leave the denomination, and the local court in Blue Ridge agreed with the local church and found that the United Methodist Church trust clause is unenforceable. And so that was really directly on point in that case. Both the Blue Ridge case and the SMU cases are on appeal right now. The appellate briefs have been submitted. They're waiting oral argument, and after oral argument, there'll be a certain period of time and a decision will come out. But in the interim, a number of the churches banded together within the state of Texas and went to their annual conferences and said, listen, we want out. We don't think it's fair that we have to pay for a pension obligation that doesn't exist, because again, the pension's fully funded. We will negotiate a way out by paying you a certain amount of apportionments, and then we'll leave. In what happened in at least two of the conferences is the conference said, well, we can take nothing, or we can end up in litigation and probably lose everything. And so a decision was made to allow those churches to go. So hundreds of churches left en masse in Texas, primarily based on they had leverage. They had the case law that supported them, both from the experience with the Episcopal Church and the experience with the Presbyterian Church and the two district court cases challenging the Methodist trust clause. So that's what happened in Texas.
So does the Texas rule apply to all states?
It does not. It's just limited to Texas. Now, it's persuasive authority. When we litigate these cases, we always talk about the Masterson, the Salazar case. We talk about the Blue Ridge case and the SMU case as well. But generally speaking, because of the great weight of authority in those cases, courts will look at those favorably, but it's not authoritative. In other words, it's not like in Texas where a local court in Texas would say, I don't have the appellate authority to rely on to invalidate the trust clause because it's just a state law case. Remember that years ago, the United States Supreme Court decided a case called Jones versus Wolf. It left it to each state to decide how local church property disputes would exist and how they could go forward. And because of that, you have every state has their different parameters and their different ways of allowing churches to leave. Texas allows churches to leave.
All right, well, thank you for your insight, Dan. If your church is interested in hiring our firm to help you through the disaffiliation process, please reach out to our office at 313-859-6000 or email us today. Thank you.